Welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with my fellow litigators, Nathan Seltzer and Clayton Calvin.
Hey.
And we are... I don't know. At this point, do we even say we're bringing you the Supreme Court cases of this session? I don't know.
They got to be bringing them to us, in fairness to us.
That's the thing, though.
Yeah.
Last week, we were expecting some interesting, we're all going to talk about, birthright citizenship, but they were like, actually, bankruptcy.
A pharmacy, they've got to stop doing their jobs and give the people what they want. Just
exactly.
Kidding. I don't believe that at all.
They should do one punchy case per week so that we have something to talk about on this podcast.
They have absolutely no compassion on our podcast. That's really what... So we are not, in fact, talking about Supreme Court cases this week.
Mm-hmm.
Instead, we actually are going to talk about a case that was denied en banc review this week from the Fifth Circuit, which is exciting for us, and we'll get to why it's exciting for us in particular, for the Texas Public Policy Foundation. But it's also just, it's a good day in America. And honestly, this is a great case. We didn't have the chance to cover it when it initially came down from the Fifth Circuit. This is McNutt and the Hobby Distillers Association versus the U.S. Department of Justice.
And honestly, it's good that we're covering it now because it embodies so much of the way that we think about this issue legally that it's good to sort of shed light on it before it goes up to the Supreme Court.
That's true. This one will almost certainly, they're certainly filing for cert. I don't see any obvious vehicle problems with it. And considering that the Fifth Circuit struck down a whole federal law, I feel like there's a good chance that it gets taken.
Federal law from 1868 or something like that?
1868, a very old one.
120 years or whatever.
Yeah.
We could be talking about this case again in season 2 of the podcast.
That's true. That would be fun. We can have a last time on and do a little flashy thing on the bottom of the screen. I don't know.
But right now, this case is excellent. It's a great day for America if you read this case.
Yes. Yeah,
Not
it
just
absolutely is. This is a fantastic case. But it hinges on a particular aspect of jurisprudence that we as CAF, we as the Texas Public Policy Foundation, handle all the time, which is the necessary and proper clause. So you guys, our listeners, are going to get, for really the first time, an inside look on some of the cases that we are actively working on currently. So we're going to bring some of those to you through the course of this. But let's start with what the Fifth Circuit said and did in this case. And then we'll move on to how that applies to some of our current pending cases. Nathan, you want to give us just a 1,000-foot view of the facts in this case and kind of the legal background?
Yeah, so first of all, we'll start with 1869 because if we're going to go to 1,000 feet, let's go to really
super
far back.
More like 160
so we're
years
in
ago,
the
not 20, like you said earlier, sorry. I just have to clarify that.
Yeah,
I do
absolutely. So in 1869, Congress, because they had nothing better to do apparently in 1869, which is the aftermath of the Civil War, they're working on the 14th Amendment. They passed the whiskey distilling, home distilling ban. And what this did is it prohibited, Clayton shaking his head.
Don't tread on me.
What they did is, what Congress did is they prohibited the at-home distilling or creation of spirits, whiskey, things of this nature, and bourbon, even all forms of distilled spirits at home.
Great American traditions.
Yeah. And they did this. At the time, they didn't really justify what power they were doing this under, and that comes up in this case. But fast forward 150 years, the law has not really been challenged in a meaningful way where plaintiffs have come in and said that this is an unconstitutional infringement on their rights until McNutt and the Hobby Distillers Association and a couple other plaintiffs bring a case saying that they would like to distill liquor at home and they can't because of this federal ban. So in the lower court, the court decides that under both the taxing power and the commerce power, that the ban is not constitutional, and so it should be struck down. And they decided that plaintiffs have standing.
Well, okay,
Yes.
so
Some
some of the plaintiffs have standing, and this is where I'm just going to draw you off for just a little second. So some of the plaintiffs who hadn't been prosecuted or received any active threats of prosecution from the government, those plaintiffs, the district court said didn't have standing. So those ones were kind of kicked to the side. But McNutt himself got a letter from the Department of Justice, I think, saying, hey, it looks like you're purchasing stuff that will allow you to do this.
Yeah, so he was, McNutt was producing ethanol for fuel He was distilling his own ethanol fuel, and it's a very similar process, apparently, according to Judge Jones, at least. It's a very similar process to produce alcohol for consumption. And so they sent him a letter warning him that if he was to produce alcohol for consumption, this is back in 2014, by the way, just to show you how long these things take to percolate sometimes, that if he were to engage in alcohol for consumption on his property, that he would be in violation of this statute, which is the whiskey ban, the distilling of whiskey ban.
Mm-hmm.
So this led to the lawsuit, of course. Some of the plaintiffs did not receive a letter from the Alcohol and Tobacco Tax and Trade Bureau, but they're still subject to the law. And so that
and they declared an intention, a serious intention, to distill their own alcohol. But for the law, right, they would be distilling their own whiskey.
And the law says, this is relevant to the case, the law says that you can't distill whiskey in your dwelling place or in the yard of a dwelling place or a shed. So it's sweeping pretty broadly that they want whiskey distilling not to occur. And this is what the law has basically been interpreted as since it was passed, that whiskey distilling is not to occur at a residence or the premises of a residence.
And importantly, it's a prohibition.
Right.
It's a blanket prohibition.
You just can't do it. Not
this
like
isn't,
we'll tax you if you do,
right,
or you have to register. You know, like a lot of exercises of the taxing power are, you got to register, and if you don't, so that we can tax you, and if you don't, then we charge you, put you in jail. This is just like, nope, this is a ban. And
a license, it's required to get a license. That makes sense for taxing purposes. You fill out a license, and then they know that you're going to be one of the taxable entities that's paying taxes into this. But they also, under the Commerce Power, I would have expected this to go up under the Commerce Power, but the Justice Department didn't challenge the lower court's ruling on the Commerce Power. So they only challenged the lower court's ruling as to the taxing power. And they said they had the power to ban at-home distilling under the taxing power. And that's the posture that we get to the case here at the Fifth Circuit.
So when this gets up to the Fifth Circuit, where we're standing is some of our plaintiffs have standing and some of them don't. And all of them are appealing that, except for the ones that said you have standing, obviously. So the plaintiffs that are, they're cross-appealing, basically, saying, actually, we do have standing. Can we please get a ruling on this? And the Department of Justice had abandoned, just full-scale abandoned, any claims to the Commerce Clause.
Right.
Do we know why? And I'm not asking you to speculate. This is just a legitimate question. Do we know why?
And I would have to speculate if I were going to venture there.
So, even Justice Jones doesn't speculate. She merely forcefully says in a footnote that they forfeited any Commerce Clause argument because they didn't raise it on their appeal.
So on the appeal, the only attack that they make is a taxing clause. Mm-hmm. So what is the power of the federal government over taxation?
So it's to lay and collect taxes.
Right.
That's what
really simple. The Constitution gives Congress the power to lay and collect taxes.
So of course that means that they can ban the activity also.
No, that is not what that means.
Yep.
It actually is the opposite, right? Like if you are going to tax an activity,
you're going to want to enable it so that you can then get the taxation from it.
Yeah, like you're supposed to be raising revenue. So like if
you want the thing to happen so that you can get the money from the thing.
You're preventing yourself from exercising actual taxing power when you ban it.
Exactly. Well, okay, so I got a little ahead of myself. Let's start with standing because,
we have to start with standing
every
time.
All we do anymore.
Yeah.
Court comes down solidly on the side of no, all of these people have standing.
Right.
They've declared an intention, and I'm just going to read the way that the court summarizes the standing in this particular area. An official threat may satisfy the injury in fact element, the official threat in this case being the statute itself, when 1, the plaintiff has, quote, an intention to engage in a course of conduct arguably affected with a constitutional interest. 2, that conduct is proscribed by statute, proscribed here, not prescribed, meaning you're not allowed to do it. And 3, a credible threat of prosecution exists. And they cite Susan B. Anthony List v. Dreyhouse. And that test of credible threat of prosecution here was met not by letters to all these other people, because most of them didn't get letters, but by McNutt's letter that said, we're going to prosecute you.
And if everyone else is similarly situated to McNutt, then that's obviously credible.
This is proof that they're at least enforcing this particular statute, and therefore there's a credible threat of prosecution of anybody that's going to be operating under the statute.
And the Fifth Circuit is somewhat unique here in terms of standing because it's very generous to plaintiffs. You don't have to show that the government has already come after you. You can just say, right now we're in the crosshairs of the government, and that is that's enough. We're the object of the regulation, and we are sitting here, and we want to do the thing that's prescribed, and so we can challenge it.
So I think combining that with the letter, I think shows that, because sometimes the government will argue, well, we don't prosecute that statute. Like that's not we don't enforce that.
Especially
that's been on the books for 100 years, but it's never been prosecuted. And we've talked about those statutes on this show before.
Right.
That this has literally never been prosecuted. This is not one of those statutes.
Yeah. So I think to say that, like, it's not like the letter gives these other plaintiffs standing. It just takes away the government's argument that, like, this is not a statute that we ever enforce. Like clearly you do enforce it if you're thinking about enforcing it.
Yeah.
So just make that distinction.
If you've sent a letter threatening someone with prosecution, threatening one person with prosecution, you might as well have sent it to everybody.
Yeah, and if you're saying you're only going to enforce against some people and not others, then you've run into a whole other problem.
Now we have an equal protection
of
problem. Yeah. Now we have a whole other problem. And then what is interesting, and we'll come back to this in a minute, for my purposes, in some of our case, is organizational standing. There's a quick little note here about organizational standing and the Hobby Distillers Association. So Hobby Distillers has standing, and here's why. They proved the three elements: that its members would have standing to sue in their own right, that they're trying to protect interests that are germane to the organization's purpose, which is real obvious here because they're the Hobby Distillers Association, and neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. In other words, nobody's looking for damages to recompense an injury that they've established, right? It's not like, if you tort someone, if you rip somebody's arm off in a car crash, we have to have that person particularly participate to say, here's what my damages are.
Yeah,
that's not what this is.
Harm.
They want one injunction that applies equally across the board for all of them. That's what they're looking for. So the Hobby Distillers can sue on behalf of their members because, as we just established, McNutt and others have standing, and they are members of the association. And also, neither the claim asserted nor the relief requested requires the participation of any particular member. So, associational standing is a powerful thing, especially here in the Fifth Circuit. So it's nice that we have that kind of that re-emphasis that, these people actually do have standing to sue.
And we want them to have standing because we want people to not necessarily have to put themselves in the crosshairs of government to be able to bring a lawsuit. So that if their civil rights are being infringed, it's not a small thing to sue the federal government. A lot of people feel like they're going to be the target of retaliation. And so an association can step in and sort of act as a shield to that person and say, our members are being affected.
Right.
And although in this case, some of the members are actually part of the lawsuit, and that's mostly to cure any problems that might exist with the associational standing if that had come up. But in this case, they didn't need to.
Well, and also there's a judicial efficiency aspect to it, too, because if associational standing wasn't available and in a post-Trump v. Casa world, every single one of these people that are in this association would have had to sue independently in order to get the relief that they're requesting. And the lawsuits would be identical. And so therefore, we'd end up in a place where now we have 393,000 lawsuits when we could have just had one that was the association for all of them, and all of them end up getting the relief that they're requesting.
Yes. Civic society doing its job. Associations.
Exactly. So that's nice. So the court says, very helpfully, all of these people have standing. And now we can move on to the actual question of, is this a tax? And you guys have already kind of tipped the hat that prohibiting an activity, prohibiting the production of a thing, is not a tax. This feels really obvious to me. Does this feel obvious to you guys?
It does feel obvious to me, in fact. And Judge Jones very, very nicely goes into a lot of the original meaning of what it means to lay a tax, assess a tax. I don't need to read all the definitions here, but she goes into Webster's dictionary from the time, and nowhere does it include to prohibit. It's just to charge.
And so we have to go then to the necessary and proper clause. If it's not, clearly a prohibition is not a tax. I think we can just say obviously.
So it does not fit within the taxing power of the Constitution. And importantly, just the background principle, probably most people know, but the federal government is different than the state governments in that it is a government of limited enumerated powers. And if the power is not specifically granted in the Constitution to the federal government, then the federal government cannot exercise it. So Taxing is one of those. It was debated in the Federalist Papers and everything that we're going to have, the federal government is going to be able to directly tax American citizens. We agreed to that. But, it has to be, the word is tax. That's what, that's the power that was granted to the government.
And this is,
so if it's not that, it has to be justified by another affirmative grant of power somewhere in the Constitution. And that kind of catch-all provision in Article 1, Section 8 is the necessary and proper clause.
And there's an interesting discussion that Judge Jones kind of starts out with, which is that conversation that the founders had about whether or not the necessary and proper clause is an independent grant of power. Mm-hmm. And I think we have some maybe confusion as a society about what the necessary and proper clause allows the government to do. So, Clayton, will you start just kind of with like our theory, the TPPF theory, which I believe is echoed almost perfectly by this opinion, on the necessary and proper clause?
Well, yeah, I mean, as you said, there's some confusion. It's not just in our society, but also in the jurisprudence surrounding this issue. The Supreme Court, for example, has never like squarely taken it up. It sort of has in some like a famous concurrence by Scalia in 2005. Talks a little bit about it, but the government likes to argue. It advantages the government to argue that the necessary and proper clause supplies this independent, free-floating, like second bite at the apple, as it were.
Right.
Like if we don't find our power anywhere in these other 17 listed,
it's like
specifically enumerated rights,
the like, preeminent
here's another
argument.
Yeah, but. No, that's wrong.
That is incorrect.
And it's not just our opinion; it's objectively true.
So, I'll just jump in here with what Judge Jones says about this. That she's quoting Prince v. United States, and she says the necessary and proper clause has been characterized as the last best hope of those who defend ultra vires congressional action.
Right. Yeah. Second of those who want second bites at the apple.
For those who don't speak Latin, what does ultra vires mean?
Without exceeding authority.
Exceeding authority. Beyond, so it's the last best hope of those who have exceeded their authority and want to keep exceeding authority. They're going to turn to the necessary and proper clause and say, this is my grant of power. Yeah. This is where the Constitution says
and there is a
that.
legitimate way to do that. And an illegitimate way to do it. The illegitimate way is to say it's a free-floating, independent, grant of power. The legitimate way is to say that is to look at the structure of the Constitution and say this little catch-all provision, which doesn't catch all, but necessary and proper clause has to be attached to one of the other enumerated powers. It has to be necessary and proper to the exercise of one of the other powers. So you got two words there, you got two prongs, you got necessary and you got proper. Those have, much ink has been spilled about what that means, but they originate from a case called McCulloch, a very famous case called McCulloch v. Maryland in 1809, I think 1809. And they're basically defined to be necessary. The power or the exercise of power has to be plainly adapted to a legitimate end, which is to say an enumerated power. And then to be proper, it has to be consistent with the letter and spirit of the Constitution. So that many cases have fleshed out what that means in different contexts.
Let me read the language. You nailed it. But the language from McCulloch is, let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution are constitutional. That's a lot of asterisks.
It's not a, it is.
On how we interpret this.
And it's not like the clear, it takes a lot of cases to sort of distill that down into like analytical prongs and so forth. But a
lot of those cases that distill that into analytical prongs are not taxation cases. They're Commerce Clause cases.
Commerce Clause cases.
That's where we see this conversation happen, starting with Justice Scalia, like you said, I think in 2005, and progressing. His dissent eventually becomes the majority, or concurrence becomes the majority opinion, which is this kind of two-pronged, necessary and proper clause, that it must be plainly adapted in order to be necessary, and it must be proper in that it must not be an infringement on...
It can't go against the grain of the rest of what the Constitution says.
Right.
Like you can't interpret, this is necessary to achieving this end, but it violates everything else, the whole structure that we see. That's not that would be another reason that it would not fit within the necessary and proper clause.
Right.
Judge Jones quotes Publius Alexander Hamilton saying that the propriety of a law in a constitutional light must always be determined by the nature of the powers upon which it is founded. And so proper, at least as Judge Jones conceptualizes it here, is really looking at the structure of government and whether this power is properly allocated to the legislative branch.
Mm-hmm. And so there have been different, I don't know, we can talk about Commerce Clause maybe a little bit later or something.
Yeah, we'll get into it, yeah.
But it all is to say, like, here, like this novel grant of authority to straight out ban something is not going to be, first of all, it's sort of an exercise of the police power, which is a state function, not a federal function. Mm-hmm. And so it's not going to be a proper way of getting at taxing.
Right.
So we know banning isn't taxing itself, but it's also not necessary, and because it impedes taxation, as we
right.
say, but also it's not proper because it's just like so far outside.
The prohibition of something like this would be a police power. This is something mm-hmm. that is properly relegated to the states. This doesn't look like it doesn't, it walks like a duck, it quacks like a duck. This is a police power objective that is currently being upheld or currently being imposed by the federal government, and that's improper.
Right.
That's
in
what
our
the Constitution
country
prohibits.
and our system, if we want to ban home distilleries, which I don't see why we would do that, but I'm sure there are probably reasons, then it has to be done state by state.
Yeah. So
or a constitutional amendment, right?
Yes.
So we can't just.
Well, I was about to say, which would be so ridiculous. And I'm like, oh wait, that kind of did happen. We literally amended the Constitution to be able to
We actually did once, but
ban
then we
alcohol.
unamended it. It's fine. Don't worry. Nothing to see here. Okay, so at the end of the day, what Judge Jones and her faithful compatriots decide is that no, this is not a proper use of the taxing power, and therefore Congress did not appropriately exercise power in laying this tax, if you will, in passing the statute,
tax ban.
And therefore it's unconstitutional. And that's where we've landed for now. That is the close of the chapter. En banc was denied last week. And en banc review being if they kind of had this intermediate appeal sort of from the circuits where if someone loses before what we call a panel, a 3-judge panel, they are allowed to go and present their cause to the entire court and say, hey, would you guys maybe all like to take a shot at this together at the same time? And very rarely, although with I think more and more commonly recently, but very rarely, the entire court will say, yeah, actually, we'd like to take a swing at that. And here the court said, nope, we agree with Judge Jones. Well, they didn't say they agree, but that's sort of implicit in this.
What is it? Probably the majority.
We're not interested in hearing all of this again.
We think these 3 judges did a fine enough job, and we're not going to come. Because each circuit has 20 between 15 and 25.
Yeah, I think we have 17
judges.
in the
so you can ask them to hear them all together.
Right.
But that was denied. And
that was denied.
Presumably they're going to appeal it to the Supreme Court.
Yeah, I think there's probably a petition for cert coming. I've heard that there is a call out for amicus on it, so almost certainly a cert will be filed on this one.
Yeah.
So
I want to read this one section. It says, Congress has essentially and improperly, relating to necessary and proper clause, invaded the reserved police and regulatory power of the states, to your point.
Mm-hmm.
So this is not Congress violating the separation of powers between branches, but the separation of powers between
the feds and the states.
Right,
yeah.
right.
Which is an important bulwark of our liberties.
Yeah, it's an incredible thing because we don't often see that distinction made in separation of powers.
Mm-hmm.
Right. So this going up to the Supreme Court, which I don't know, hopefully it does. I don't want to forecast anything or anything, but this is far more important than just whether certain taxes are allowed.
Right.
The ripple effect of this could be actually quite large because it has to do with how we interpret necessary and proper clause, and therefore how we interpret the whole scope of
all
federal
of our
power.
Commerce Clause cases.
Well, and federal power. Because if this, if it applies to multiple, enumerated powers, then basically what we're saying is these are the bounds, the ultimate bounds of the federal government's authority.
And what's interesting to me about this is that I don't think that Judge Jones here is doing anything new. I don't think that she's making an argument that hasn't been made a million times before, maybe in less articulate ways. But like
they're crystallizing all of this.
She has crystallized and distilled all of this and saying this is what our jurisprudence says, and I don't think that she's out of bounds on this. I can't imagine that she's doing anything new here.
It's the most plausible synthesis of everything that is already out there, but it's a great crystallization.
So she quotes a case from 1869, United States v. DeWitt. Says she cites a case from 1869. So like 1 year after actually this ban went into effect. The Supreme Court long ago rejected Congress's attempt to ban one product in order to further taxation of another product. And that's talking about the way that they were banning certain oils because they wanted to tax other oils. And they're like, well, it'll increase, if we want to tax illuminating oils, if it has naphtha, we're going to ban it. It's like a very kind of odd statute passed by Congress a long time ago. And they said, no, you can't ban one thing in order to increase tax revenue of another thing. That's not within the taxing power. And so this, I think, is even further from the taxing power because they're not arguing that like it increases their tax revenue of other alcohols or something like that.
Right.
They're just banning the
and their
activity.
whole argument, at least at this stage, in this moment in time, their argument is that we can ban this because if we didn't, people would evade our taxing structure.
Right.
Which is kind of nonsensical because either they're going to break the law by just doing the distilling and bootlegging.
Yeah.
Or they're going to evade your tax ban. Both are violations of the law.
But think about what it means if I can ban something because you might evade taxes by doing it.
Yeah, I can ban everything.
Literally everything. There is no intelligible
like that actually
principle.
is not hyperbole. That means everything.
And Andrew Grossman, who argued this case for the distillers, is like they could ban catch in your backyard.
Yeah.
Because if they're saying that would be evading a tax on playing catch or something. Like it's literally
like, pause. You said the tax on the catch.
Players.
We have to talk about that first.
Yeah.
So there's no limit on the power if that's the power.
Yeah.
So.
Right. Yeah.
Which also plays into that proper prong too. It's not proper if there is no intelligible limiting principle.
Yeah.
Right. Okay, so that brings us to, Clayton, one of your cases. We affectionately refer to it in-house as FinCEN. But what case is FinCEN? Tell us about that.
So FinCEN is, we call it that because that is the defendant. That's the person, or that's the agency that we're suing. It basically uses the same. We were very happy to hear Judge Jones, the way that she thinks about these issues, because we basically use those same theories with respect to the commerce power, and rather than in the context of taxation, it's the context of commerce. And we're basically the FinCEN, the agency. It's an agency under the Treasury, is requiring. Or they promulgated a rule that asks for a lot of like private sensitive information whenever a person transfers a piece of residential real estate into a legal entity or a trust. And it tries to justify this based on its commerce power.
It's not just the commerce power, but the interstate commerce power.
The interstate commerce power. So
top line view of this. If, for example, I own a house and I say, you know what, I want to put my house into a trust because when I die, I want my house to go to my kids and not pass through. If I decide I want to put my house into a trust, I have to report a bunch of personal sensitive information to FinCEN?
That one is likely covered by one of its exemptions. But let's say you want to do the exact same thing but put it into an LLC.
Okay.
Then yes. Then you have to put, like, it's a completely innocuous, like innocent, good purpose, and it's also only takes place, importantly, within a state. And your residential property is only, by definition, it's like the paradigm example of a non-fungible good or asset that is literally incapable of crossing interstate lines. Maybe interstate lines can cross them, but they cannot cross interstate lines.
See the Red River case.
Yeah. We have other cases about that, actually. So we're like, excuse me, this is not part of interstate commerce.
This is not interstate commerce. Now, the obvious question here is, but LLCs are businesses, and businesses do commerce, and commerce is interstate commerce. There's an underwear gnomes problem there a little bit, but like so why is it not just, but an LLC is a business and therefore this is governable under some of the many fingers and tongues of the interstate commerce clause?
Because, well, first of all, it is not. It's a vehicle for commerce. It's not necessarily commerce itself. And so there's a case called GDF Realty that directs the courts to look like, no, you have to look at the actual activity that's regulated, not the surrounding activity that might be commercial. Like in that case, the government was trying to protect a bug from a Walmart development, and it said, well, look, we're affecting the Walmart development, and the court said, no, you're trying to take the bug. That's not commerce.
Right.
So LLCs themselves are not commerce, although they might sometimes be used in it. But that's not the only question that we ask, because there's both the necessary. Well, first of all, yes. So it's not in commerce.
It's not in commerce. It's not interstate.
And also the activity, the transfer of a inherently local thing, that being residential real estate, also not commercial real estate. That's not what the rule covers. It's residential, so not in commerce, into an LLC. That activity, that transfer, is not commercial. So,
and we're talking about an LLC within the same state.
Yeah,
so
and
Texas
LLCs, by the
property
way, are like
being
exclusively within the state
Right.
government too. You don't make federal entities like that. They're state based. So it's another element of state law.
This is not intrastate at all. This is a purely intrastate function of moving title to an LLC.
Mm-hmm. And they're doing this, they're not necessarily, like sometimes you could see like you're going to sell something to a business, that would be commerce. But if you own the LLC and you own the property and you transfer the property from your personal ownership to the LLC ownership. You just want to own it,
yeah. And there's no money changing hands, anything like that. And you're just in your own, hometown or whatever. It's like literally not interstate commerce. So if it's not interstate commerce, then the government needs to use
commerce at all,
or even commerce at all.
Yeah.
Has to be justified somewhere else.
Yeah, the government has to find somewhere else.
We've got a last resort of an ultra vires
actor. What was it? Yeah, whatever she said. The second bite of the apple here.
Last best hope.
The last best hope. Yeah. That makes it sound so poetic. It's like Princess Leia when you say it like that.
Yeah.
Your only
it's
hope, necessary and proper.
Help me, necessary and proper clause. You're my only hope.
Exactly. But yeah, so that's inevitably what the government has argued, and they say a lot of the same arguments of the government that were rejected here in the McNutt case. That necessary and proper clause is this free floating grant of power. No, it's not. What we're holding the government to account is to say you have to demonstrate how this is, and you can't. How this regulation of inherently local activity is both necessary, which is to say plainly adapted to, and proper, doesn't violate federalism principles, necessary and proper to the exercise of the commerce power. And we contend that it is not.
And where is that right now? Where is that case at this moment? It's not at the Fifth Circuit yet.
It's in a very interesting
kind of
posture.
A weird procedural posture.
Yeah, that I've never encountered before. But the judge ruled on it, issued what he described at the time as being a final ruling in favor of the government. Although a different case actually struck it down and vacated it on statutory grounds. But our judge ruled in favor of the government, but then did not issue an opinion. And still hasn't, which is, that's fine. He's considering things such as the intervening case, such as McNutt, which actually came down during that interim period. So that might actually affect the analysis there. So we're just waiting.
And this is in the Northern District of Texas? Mm-hmm. Okay. So we're just patiently seeing what happens there. And I guess we'll keep everybody apprised as more developments there happen. Mm-hmm. And then another case that is important in this necessary and proper clause context is our machine gun case, as we affectionately refer to it in-house. It's Temple Gun Club versus Blanche.
Which has almost more similarities, I think, with
a lot more in general, more similar than FinCEN. Because in some respects, we structured our claim basically the same way that the hobby distillers did. So our main client is the Temple Gun Club, and we have several individuals within the Temple Gun Club that are named plaintiffs for us as well. And their claim is the members of the gun club want to be able to own machine guns. And not only that, The club itself has many gunsmiths who know how to convert machine guns that they already own. And we've actually found several of these members have machine guns, or have rifles that were made in Texas. Therefore, they haven't been, in this stream of commerce to begin with, that they can turn around and machine in-home into machine guns. Mm-hmm. So that purely intrastate action of converting something that I own into a machine gun is what's at issue in our case.
They have the ability to make that.
Yeah, the ability and the intention and the present intention to do that. However, the federal court not allowed. Congress has enacted what's called the Hughes Amendment 922-0, which is a blanket ban on machine guns created after 1986. So machine guns that were in existence before 1986 are grandfathered. You can still buy those. They are extremely expensive, but you cannot manufacture except for military or police purposes, and you can't possess machine guns made after 1986.
It's a really weird situation to be in, where the argument is it's not safe for you as a normal, ordinary person to own a machine gun unless it's older.
So the argument isn't that it isn't safe for you to own a machine gun. That's kind of more of a Second Amendment kind of claim. The argument that the federal government makes, and this was made effectively, actually, we are, and we recognize this, stopped in some sense by precedent in a case called Knutson, which is a Fifth Circuit case. And Knutson held that machine guns affect commerce because they are the ultimate product of interstate commerce. And Congress clearly wanted to cap the number of machine guns in commerce at pre-1986 levels. So in other words, this thing is part of commerce. This object, this machine gun is part of commerce. And Congress can regulate this part of commerce by capping it at that specific 1986 level. So at least on its face, this isn't something that the federal government is trying to say, nope, this is too dangerous, you can't have this.
Which would be an exercise of police power.
That would be a blatant exercise of police power.
Which is for states.
Right. The argument is instead, we don't want too many of these floating around in the economy, so we're going to cap this number at 1986
And that's interesting because it's not a straight up ban like this distilling law. It's kind of, it is a
quasi-ban. Yeah.
But it has a more, clever commerce justification, I guess. But it is effectively banned.
Yeah. Obviously. So I just like the government tried to argue in the distilling case, they can still, you can still make it in that one shed, and Judge Jones didn't buy that, but we're just trying to channel the commerce or the activity into things that are easier for us to tax.
Right.
And so in the same way, it's the Temple Gun Club, the people who are able to machine these guns into machine guns, they're not allowed to engage in that activity. They could go out and buy a totally different weapon that was made before 1986 and comply with the law that way. But if they wanted to just convert their existing firearms into machine guns, they couldn't do that. So that's just a categorical ban on the activity.
In the name of whereas so in McNutt, they're saying this ban indirectly or backwardly facilitates taxation. Here they're saying this ban indirectly facilitates regulation. But there are really three things in truth. There are bans, there are regulations, and there are taxes, and those are actually very different activities.
Yeah.
So without tipping my hand too much, because we are in the process of preparing and filing our answer to the government's motion to dismiss, because their motion to dismiss was quite understandably, Knutson has already ruled on this exact issue, and Knutson is controlling law in your circuit. To which our response is, yeah, we know we're trying to overturn Knutson. That's what we're doing here. Yeah. We were very open about that in our complaint, and we'll continue to be open about that. That's the goal here, is we think Knutson was wrongly decided, and we're going to ask the Fifth Circuit to overturn it. Fun fact, the only way for us to do that in the Fifth Circuit is to get an en banc. So like we were talking about earlier, it doesn't matter really what the panel says. The panel is also bound by something called horizontal stare decisis by Knutson. So they are going to be bound. So we have to bring it in front of the entire court and say, hey guys, we think that you got this wrong back in, I think, 2007.
Yeah. Which requires losing at the district court level and then losing again.
Are there interim ways to argue how this is actually compatible for the time being with Knutson in different ways?
Yes and
Because-
no.
yeah.
So there has been some development in the law. Again, I'm not going to tip my hand too much, but there has been some development in the law since Knutson was decided.
Right,
So
yeah.
it was decided, I believe, pre-Morrison. So some of that jurisprudence has changed a little bit.
And Morrison is a big, it's
Was
one
a
of those
big
big
necessary
necessary
and
and
proper
proper
case.
clauses that we were
Right.
referencing earlier.
Right. And also now we have McNutt, which will be helpful insofar as, like you said, it kind of distills what's already there and shows where Knutson is kind of wrong on this.
Distills, yeah.
Crystallizes.
Dad joke. Let's go.
But yeah, I mean, our argument is just at its core that same necessary and proper clause argument that this is not plainly adapted. And even if it was plainly adapted, this is obviously a function of the police power of government.
Yeah,
this is
it
not a
violates
function
the
of
structure of
right.
government.
It violates the
Because
structure of the
imagine,
Constitution.
I mean, we talked about it a little bit, but like, 'cause the lack of limiting principle and how scary that is. But also think about like, if like there's a reason we didn't come together at the Constitutional Convention and give the federal government the police power
Right.
to go across the whole country. We decentralized that. Those really sort of life or death situations,
exactly.
encounters between the state and the individual. We decentralized that. That's like the point of the way our system is set up. And then we gave the federal government a few powers, like defend the whole country from outsiders, make sure that our common market is facilitated, and that's about it. But anyway, like just think about why this is important. Why we don't want the federal government exercising police power, even if sometimes people think it's a good
on
thing.
a philosophical level, I think that it is something that we as conservatives like because we like small government, but also it's something that even liberals should like because of that
it's
understanding.
definitionally liberal. I mean, it's
Right,
about
right.
protecting liberty. Yeah.
It's about protecting liberty. This is something that will protect you, at least in theory. The closer your government is to you, the less likely they are to take your life and liberty without
Right.
process. So, so all of that to say, we have a lot of important things floating around in the CAF pages right now. I will keep you guys updated on the motion to dismiss, which needs to be filed by next week, I think. And
What are we doing a podcast for?
I know. I think Chance is working on that today, actually. So, Nathan, before we close, do you want to give us a scorecard on McNutt?
Yeah, so the Fifth Circuit, in a unanimous panel opinion, which is just 3 judges, they agree with Judge Jones that the federal home distilling ban that prohibits you from making consumable liquor in your house, that is not constitutional, and that I guess people can engage in I won't give legal advice, but
Don't give legal advice.
It appears to be unconstitutional, at least in the Fifth Circuit.
yeah, it appears to be unconstitutional to ban it for at least the federal government.
Woo! All right. Perfect. Thank you guys so much for being here, and thank you, our dear listeners. If you've enjoyed our conversation today, please leave us a comment. Tell us what you thought, give us a review, and join us next time for more Rightly Decided.